I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about it.
All right, guys. Today we've got one of the most ridiculous sovereign citizens I've ever seen. Seriously, how are people still trying this nonsense in 2025? This guy can barely read, yet he walks into court acting like he's some master legal expert ready to outsmart everyone in the room. And his main argument? He claims he isn't getting a fair trial because he only had 1 hour to study the law while the prosecutor spent 7 years in law school. I mean, you genuinely cannot make this stuff up. That's like showing up to a marathon with zero training and complaining the Olympic runners had an unfair advantage. This hearing is about to be an absolute disaster, painful to watch, but somehow still hilarious at the same time. Let me know what you guys think in the comments while we watch this guy completely embarrass himself in court.
State of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or an adequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
My goodness, this man can barely get through a sentence, and now he's standing in court trying to read motions like he's some legal genius. Be honest, what grade level do you guys think his reading is at? I'd probably say around 6th grade, and honestly, that's being generous. But the funniest part is that he's seriously complaining about not having enough time to study the law. Sir, do you actually think the judge is going to delay your case for the next 7 years so you can go earn a law degree? The entitlement here is unreal. Back in the day, if you didn't know how to do something, you found someone qualified who did. You didn't throw a fit and expect the entire world to bend around you. The court already gave him multiple choices. Hire an attorney, accept a public defender, or represent yourself if you truly understand the law. Clearly, he does not. At this point, what's next? Is he going to ask the judge for extra time so he can become a Supreme Court justice too? Let me know what you guys think about this clown so far, and let's get back into it.
All right, go right ahead.
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court, and for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out, and when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on, and I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion, prosecutors rule 3.8, didn't take action or all actions making sure my rights were protected, and rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules. And
is anybody else just waiting for the judge to say, nice speech, motion denied? Because honestly, that's exactly where this is going. This dude really stood there reading his motion like he was delivering some historic national speech. I swear, I think the judge only let him continue because it was entertaining watching him ramble. Judges don't even have to entertain nonsense like this. They can deny ridiculous motions immediately, especially when someone is clearly wasting the court's time. This is basically a perfect example of that. There are actual court rules designed to stop people from filing baseless arguments exactly like these. Courts can even sanction people for wasting judicial resources with nonsense motions. But apparently this guy thinks if he talks long enough, the judge is suddenly going to recognize his sovereign citizen wisdom and dismiss the entire case. Spoiler alert, that is absolutely not happening.
Impartial trial, miscarriage, also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end, the deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then, he doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have a third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
At this point, I honestly can't tell if this guy is pretending to be clueless or if he genuinely believes what he's saying. Personally, I think he's playing dumb because there's no way somebody facing real jail time could think this strategy is going to work. This isn't a high school pop quiz where you can just make things up and hope for the best. His entire defense falls apart the second you realize he could have had a court-appointed attorney for free. But instead of accepting free legal help, he chose to waste everyone's time filing nonsense motions and whining that he only had 1 hour to study for court. What did he think this was, an open book exam? He honestly reminds me of that one kid in school who clearly never prepared for their presentation, so they just start making random stuff up and hope nobody notices. Newsflash, everybody notices. Let me know in the comments if you think this guy is acting clueless or if he actually believes his own arguments. Let's dive back in.
And it states that there's a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And you didn't want that either. So then we went through the hearings and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws stating and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it. on both sides. I know that. It
Well, I
says
made
that.
my findings. You are able to
You
appeal
gave
anything
me
you wish,
bogus
Mr.
information. You're
Martinez.
not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's
That's right.
another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435 FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707 ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
The judge absolutely handled this perfectly. You can tell she's been dealing with nonsense like this for years. The second he started talking about federal laws and trying to lecture the court, she already knew exactly where this was going. What makes this whole thing even crazier is that this guy kept acting like everyone else was the problem while ignoring the fact that he repeatedly failed to appear in court and still hadn't handled a case dating all the way back to 2016. And then he starts arguing that the court can't punish him because he didn't pay fines, while also insisting the judge and prosecutors are somehow biased against him. Meanwhile, the judge calmly explains that his objections are preserved for the record, his bond is staying in place, and he's getting jail time because of his repeated failures to appear. Honestly, the funniest part is when the judge basically tells him, if you actually want meaningful legal advice, apply for a lawyer instead of complaining. That was probably the most accurate statement made during the entire hearing. This dude had every opportunity to help himself. The court offered him legal representation, explained his options, and gave him multiple chances. Instead, he chose to walk into court with nonsense arguments and act like he discovered some secret loophole in the legal system. That strategy clearly did not work out for him. This is exactly why understanding your rights actually matters, not so you can invent fake legal theories, but so you don't end up embarrassing yourself in front of a judge with zero patience for games. At the end of the day, courts are not going to entertain made-up arguments when free legal representation is literally standing by waiting to help you. This might honestly be one of the dumbest courtroom performances I've seen in a long time. The law isn't some choose-your-own-adventure game where you can make up rules whenever things stop going your way. Still, I can't lie, this guy definitely gave everybody some entertainment today. But yeah, guys, that's going to wrap it up. Let me know what you thought about this sovereign citizen meltdown in the comments. Earlier, I said his reading level was probably around 6th grade. Honestly, after hearing that motion, I might have to lower it to 3rd grade. Either way, it definitely wasn't impressive. If you enjoyed the video, make sure to like and subscribe, and let me know if there are any other courtroom hearings you want me to cover. I upload every single day, so there's always more chaos coming. Thank you guys so much for watching.